Welcome to Moving Forward with my host,
Karen Casino.
And myself, Ryan White. We are here today with Elizabeth Tresp with Tresp Law, APC, here in Solana Beach and Pacific Beach. We are going to talk about estate plans and, more importantly, why you need one.
Yes.
Elizabeth?
Thank you for having me, Ryan and Karen. It's always a pleasure.
Oh, great.
There are a variety of reasons why you need an estate plan, but I'm going to hit kind of the big hitters. So
Okay.
One, probate. I'm sure you've heard of probate. Probate is a process that you go through in the court system. It is public. So what some people don't realize is that if you just have a will and not a trust, most times that's going to require a probate to be opened, so that somebody has the legal authority to administer your estate. And that means it's in the public record, and anyone can go on to the Register of Actions in the probate court and pull down some very personal information regarding your estate, your life, and your family. So we don't want that. Probate also is expensive, so fees in the state of California are based on a statutory amount. So it's a statutory amount of the value of the property. That fee is for the administrator who's appointed by the court, but it's also for the administrator's attorney. And so you're hit twice as far as that goes. And it takes a long time. Probate generally, at minimum, I think the fastest probate that we've done is 8 months. That's just flying through it, no problems, very simple estate. We have had probates because of either objections or complicated assets go up to 5 years, depending on if there's litigation and arguing. So, first reason, avoid probate. No one will voluntarily and willingly go into probate, and you won't talk to anybody who says, I'm so happy that I just went through that experience.
It sounds terrible to have everything publicly reviewed like that or available for that.
Yes, it is. And it also is, it's very complicated. So some people try to do it themselves, but it is a complicated process, very form-driven, that everything has to be done in a perfect way. And it's reviewed by probate examiners who then give you notes. And if you are in a circumstance where you're administering an estate of someone that's passed, and they did not have a trust and you have to go through probate, hire a probate attorney. You will be very grateful. It will go so much faster because it's what we do all day, every day. So it's definitely worth it.
And so probate becomes the default if I don't have a trust in place. If I don't write down what I want to be done with my stuff, probate's the default.
So yes and no. So probate is going to happen if you don't have your assets in a trust and they are above a certain threshold of value. So even just you can have a probate even if you don't have a will and you have nothing, and then it's called intestate succession. So the probate code actually lays out where your assets are going to go for you. So you also have a loss of control. So a trust is different than a will because a trust passes outside of probate. A trust is a legal document that is established where you are appointing someone as trustee who can step in and manage your affairs, not just when you pass, but also if you're incapacitated. So this is the second reason, planning for incapacity. We're living longer these days.
Right.
It's just a fact. Well, for
most
a lot of
reasonable
people, yeah,
fact.
if we're lucky. And so having a trust, when you're in a situation where you're going in for surgery, or you're starting to have some cognitive difficulties, having someone that you've chosen, not the court system, not anyone else, but you've chosen, someone you're comfortable with, to step in and manage the assets that are in that trust, it gives you such a sense of peace. If you don't have a trust and you're incapacitated, and you don't have a power of attorney, which I'll go in just a little bit, your option is a conservatorship. And a conservatorship is another court process where the court and the county investigates who is the best person. You can have in your documents someone nominated to be the conservator, but that doesn't mean that they're necessarily going to be appointed. And so that's another long, lengthy process overseen by the court system. So a trust allows you to also put your wishes in writing. I want to stay in my home.
It seems like one of the biggest things, wishes in writing.
Yes. Yeah. In writing in a document that's going to help you avoid having to go through the court system.
And having control over what happens to your money, who's going to be in
Yes.
control of your health issues.
That leads me to the next one, is having the distribution provisions. So you're choosing where you want your assets to go when you pass away. So you might have lots of people are philanthropic and they have charitable wishes. You can put those out in your trust. You can create those relationships before you pass, laying out, okay, this is something that's near and dear to me that I would like to contribute. I would like to have my estate contribute to. You might have issues in your family. You might not want it to go intestate succession to people that are chosen by the probate code. You might want it to go to a niece or a nephew, or maybe all of your children are already financially solvent, very well off, done very well for themselves. And maybe there are other people in your life. You can do that through your trust. Now, this that I'm talking about is a living trust. So this is a revocable trust that will allow you to change it or amend it throughout your lifetime. So you brought up healthcare. Healthcare is a little different. So that's another document that's called an advance healthcare directive, and that's where you choose your agent. This is another big one. You're choosing at least one person, but ideally 2 others in succession, to make medical decisions for you when you can't. And you lay out your wishes in that document. Right. What do you want to happen? Do you want to be kept alive by machines if there's no chance of recovery? That's a big one, and it is an emotional struggle for the person making that decision if it's not clearly designated in writing. So trust, if we're talking about an estate plan, you have your revocable living trust. You still need a will. It's just called a pour-over will. This gets all of those pieces of personal property that don't have a deed or a title, an account that can be titled in a certain way, your personal property, vehicles, things like that. Now, a pour-over will take all of those assets and pour them over into your living trust and have them distributed per the terms of your living trust. Advance healthcare directive for medical decisions, and then of course a financial power of attorney. There are a couple aspects of powers of attorney that are critical. You can have, the powers are very broad, they can be written that way, and we have a statutory power of attorney here in the state of California that lays out some very broad access and authority. And you can of course narrow that down very easily and specifically depending on what your situation is. One key thing that you need to think about is, do you want a durable power of attorney that springs into action when you're incapacitated? Or do you want a power of attorney that's effective now, that the person, the agent that you're putting in there, can actually access and have authority, not ownership, but authority over your financial assets? And that's a distinction that is critical when you're thinking about these types of documents. And so when you're working with your estate planning attorney, you want to think about that. And if you're married, generally you'll have them be effective immediately, because we have a community property state, so there's separate property and community, and if there's an account that is in just one spouse's name, that bank's not going to talk to the other spouse. Right. And so having a power of attorney that's effective immediately sometimes can make that easier.
Sure.
You got to think about that if it's blended families, second marriages, third marriages, things like that. And you want to update it in the event of divorce or death, of course, because then you want it, if it's effective immediately, you don't necessarily want that next agent to be able to step in and do things. You probably want to adjust it to springing.
Because you want to have control
Of
over
course.
all these things you're talking about.
Yeah.
And through a trust, you can do that. You can work with your trust attorney, and decide how you want this to go. But if you don't do that, then you lose complete control, don't you?
100%. And there are a lot of different aspects. When you're choosing your estate planning attorney, just choose, it's really good to actually choose someone that also does trust administrations like we do, because they see what happens when the trust is actually administered, when either you've lost capacity or you've passed away, because there are a lot of issues that come up. So when you're drafting, you have those in the front of your mind because it's part of your daily practice. Also, trust and probate litigation. We do a lot of that. And so when we are drafting, we're keeping in mind a lot of issues that we've litigated so that we can avoid that. Sometimes people think they can just go do it themselves, but I can tell you, we've litigated a lot of those trusts, and it often just doesn't. They don't get upheld, the intent of the trustor, which is really one of the main points of a trust, is to lay out what your wishes are. But if the document isn't drafted properly and someone contests it, then there are a lot of holes, and you don't want to be in that situation.
So you mentioned 4 documents.
Yes.
Go through those again.
Yes. So you have a revocable living trust, you have a pour over will, an advance health care directive for medical, and a power of attorney for finances. There are some other ones. You always want to have what's called a general assignment, which is it's backup. It's saying that you want all of your assets to be assets of the trust, because if you forget to fund the trust, which is a whole other conversation.
I'm sure.
Yes. The state of California is great in the way that it allows a trustee or a person who has standing to, after you pass, file what's called a Hegstad petition under Probate Code 850 to ask the judge to essentially retroactively fund the trust, to show that the trustor had intent. They meant to put this into their trust, but just through inadvertence or some other reason that is a valid reason, it didn't happen. And so judges can make that decision based on the evidence that's placed before them, so that that asset doesn't have to go through the full probate process.
And you mentioned there's a minimum threshold.
Yes.
Where in which I suspect the threshold is relatively low.
For the state of California, it is. So it's always raised for inflation. And so it has varied. It used to be 166, now it's higher, it's been much lower. If you own real property in the state of California, you're above it. Most people are above the threshold.
Sure.
I mean, yes. So it's definitely something that you want to
It's safe
take
to
into
say,
consideration.
if you own property in California, which I think you said, you're going to want this.
Oh, if you own property in California, you need a trust.
And as I recall, the threshold is not maintained based on the equity; it's the total value,
It's the
regardless
total value.
of the loan. Yeah, yeah, which really means everybody in California.
Yeah.
I mean, probably everybody in the nation.
Actually, that's an interesting point when you talk about the value, because for a probate, when you're looking at the assessment for the purpose of evaluating what the statutory fees are going to be for the administrator or the attorney, it's based on the total value. You don't back out the loan.
If there is one.
Yes. Oftentimes there's a loan.
Yeah, most. I mean, I think it's very common. California has a lot of loans. Expensive.
Yes.
Yes. Yes. Wonderful. We've been speaking with Elizabeth Tresp. She is an attorney with Tresp Law, APC, in both Solana Beach and Pacific Beach. Thank you very much.
Thank you. Thank you for having me.
Very helpful.